Tonight, we examine a case that once commanded national attention and then became part of British legal history. A single investigation, a single verdict, and a legacy that has endured for more than a century. The case of Mary Jane Bennett begins in Great Yarmouth, Norfolk, in the September of 1900. Great Yarmouth, at the turn of the century, was one of the most prominent seaside resort towns on the eastern coast of England, a place whose economy and identity had been built almost entirely around the seasonal movement of visitors from London and the Midlands. The town sat at the mouth of the River Yar, where the river met the North Sea, and its geography had shaped its character for centuries. To the east lay the beach and the promenade, lined with boarding houses, bathing machines, and amusements catering to the summer trade. To the west, running parallel to the seafront, lay the old town, a dense warren of medieval origin, still carrying much of its original street plan. Between the two ran the Rows, a network of more than 140 narrow alleyways, some barely wide enough for two people to pass abreast, lined with tightly packed lodging houses that had sheltered fishing families, herring workers, and seasonal visitors for generations. By 1900, the population of Great Yarmouth stood at somewhere near 50,000 people, a number that swelled considerably during the summer bathing season as visitors arrived by train from London and beyond. The town's economy rested on two pillars, the herring fishery and the tourist trade, and in September, these two economies briefly overlapped as the last of the summer visitors lingered on the beaches while the fishing fleets prepared for the autumn herring season. The Rows themselves, though ancient in origin, had by the close of the 19th century become associated primarily with cheap lodgings, rented out by the week or even by the night to a transient population that included seasonal workers, itinerant labourers, and visitors seeking accommodation less expensive than the grand hotels along the seafront. The lodging houses were narrow, timber-framed in their older sections, and packed closely together, their upper stories sometimes leaning toward one another across the alley. Landladies in the Rows were accustomed to taking in strangers with little inquiry into their circumstances, provided the rent was paid, and a woman travelling alone, or with a small child, would not have attracted particular notice in such surroundings. It was into this setting that a young woman, using the name Mrs. Hood, arrived on the 15th of September, 1900, accompanied by a daughter of approximately 2 years of age. She took lodgings in one of the Rows, presenting herself to her landlady as an ordinary visitor come to the coast, of the kind Great Yarmouth had accommodated by the thousand every summer for decades. Nothing in her arrival distinguished her from any other mother bringing a small child to the seaside for a period of rest. She was, in fact, Mary Jane Bennett, a young married woman whose usual residence was in the district of Bexleyheath, in the southeastern suburbs of London, and the name under which she had taken her lodgings was false. Within the space of 8 days she would be dead, her body found upon the south beach of the town she had come to for the ordinary purposes of a late-season holiday. The documented record of Mary Jane Bennett's early life prior to her arrival in Great Yarmouth in September 1900 is limited. The surviving sources establish that she was a young woman associated with the Bexleyheath area of London's southeastern suburbs at the time of her marriage, and that by 1900 she was married to Herbert John Bennett, a labourer with a connection to the Woolwich Arsenal, the vast government ordnance works situated on the south bank of the Thames. The couple had one child together, a daughter who was approximately 2 years of age in September 1900. Beyond these facts, the historical record available for this account does not establish the details of Mary Jane Bennett's parentage, her upbringing, or the circumstances of her family prior to her marriage. Her maiden name is not established with confidence in the sources reviewed for this account, and no attempt is made here to supply one. What can be stated is the shape of her life as a wife and mother in the years immediately preceding her death. Bexleyheath in 1900 was a growing suburban district on the edge of London's expansion, drawing its population in significant part from workers connected to the industrial and military establishments along the Thames, of which the Woolwich Arsenal was the largest and most prominent. The arsenal itself employed tens of thousands of men in the manufacture and testing of ordnance, and it maintained detailed records of attendance and wages, a fact that would later assume considerable importance in the case. Families connected to the arsenal typically lived within a network of surrounding suburbs, commuting to the works by rail or on foot, and the rhythms of arsenal employment, its shifts, its paydays, its periods of overtime, shaped the domestic life of these households as thoroughly as any other feature of the district. It was within this world, as the wife of a man employed in or around this industrial establishment, that Mary Jane Bennett kept house and raised her young daughter in the years before her death. The marriage between Mary Jane and Herbert John Bennett had, by the late summer of 1900, become strained. The documented record indicates that Herbert Bennett had, by this time, begun a relationship with another woman, a parlour-maid named Alice Meadows, and that this relationship was conducted under false pretences, with Alice Meadows given to understand that Herbert Bennett was an unmarried man free to enter into an engagement with her. The precise date on which this second relationship began is not established in the sources available for this account, though it was evidently well underway by September 1900, when the circumstances that led to Mary Jane Bennett's death began to take their final shape. It is against this background of domestic estrangement, a marriage strained by a husband's undisclosed second attachment, that the events of September 1900 must be understood. If value is found in cases such as this one, preserved through court records, testimony, and the surviving documents of an inquiry conducted more than a century ago, consider liking the video and subscribing to the channel. Comments noting the location from which this account is being heard are always welcome. Now back to the record. The circumstances that brought Mary Jane Bennett to Great Yarmouth in September of 1900 are, in their broad outline, established by the surviving record, though the precise motivations behind them remain a matter that the historical account can describe only through the lens of what was later argued at trial. On the 15th of September 1900, Mary Jane Bennett travelled from the London area to Great Yarmouth, bringing with her the couple's young daughter. She took lodgings in the Rose under the name Mrs. Hood, a name that bore no relation to her married surname, and that appears to have been adopted specifically for the purpose of this stay. She would remain in these lodgings, under this assumed name, for 8 days until her death on or about the 22nd of September. The prosecution's account of these events, as it was later presented at the Old Bailey, held that Herbert Bennett had brought his wife and daughter to Great Yarmouth under an arrangement intended to remove them from the ordinary course of his domestic life, and that he subsequently returned to the town approximately a week later for the purpose of killing her. This was the case advanced by the prosecution at trial, and it should be understood as the prosecution's theory of the events rather than as an independently established sequence of fact. Herbert Bennett himself denied throughout the proceedings, and to the end of his life, that he had killed his wife, and the defence at trial presented evidence intended to place him elsewhere at the material time. The precise nature of the arrangement that brought Mary Jane Bennett to Great Yarmouth, whether it was her own decision, a joint decision of the couple, or an arrangement pressed upon her by her husband, is not established with certainty in the surviving record, and this account does not resolve that question beyond noting that it was and remains contested. During her 8 days in the town, Mary Jane Bennett appears to have conducted herself as an ordinary visitor to a late-season seaside resort, taking her daughter to the beach and about the town in the manner of any mother occupying lodgings for a short holiday. A photograph taken of her during this stay, showing her on the beach at Great Yarmouth, would later assume evidentiary significance, as it depicted her wearing a gold watch and chain that were missing from her possessions after her death. Beyond this photograph and the general fact of her residence in the Rose, The surviving sources do not provide a detailed account of her daily activities during this period, and this account does not attempt to supply invented detail where the record is silent. What is established is that she remained in her lodgings under the false name for slightly more than a week, that her daughter remained with her throughout this period, and that at some point on or near the 22nd of September, she left her lodgings and did not return alive. The lead up to Mary Jane Bennett's death, then, is defined chiefly by two facts that stand in some tension with one another. On one hand, there is the plain circumstance of a young mother taking ordinary seaside lodgings under an assumed name with her small child for a stay of just over a week. On the other, there is the prosecution's later contention that this stay had been arranged by her husband as a prelude to her death, a contention that Herbert Bennett denied and that the surviving alibi evidence would later complicate. The certain fact, established beyond dispute by the record, is that Mary Jane Bennett did not return to her family's residence in Bexleyheath. She remained in Great Yarmouth, and it was in Great Yarmouth upon the south beach of the town that her body was discovered. Herbert John Bennett, the husband of Mary Jane Bennett, was 21 years of age at the time of her death. He was a labourer with a connection to the Woolwich Arsenal, the government ordnance works on the south bank of the Thames that employed a substantial portion of the working population of the surrounding suburbs, including Bexleyheath. The nature of his particular employment at or connected with the arsenal is not detailed with precision in the sources available for this account. At his trial, the central plank of his defence was the testimony of a witness, Sholto Douglas, who stated he had met Herbert Bennett in Bexley after the last train to Great Yarmouth had already departed. By the late summer of 1900, Herbert Bennett had entered into a relationship with Alice Meadows, a young woman employed as a parlourmaid. This relationship was conducted, according to the established record, on the basis that Herbert Bennett was an unmarried man, free to court Alice Meadows with a view to marriage. Alice Meadows was, in this sense, entirely unaware of the existence of Mary Jane Bennett or of the daughter the couple had together. Following the death of Mary Jane Bennett, Herbert Bennett gave to Alice Meadows a number of items, including clothing and jewellery, that were later established to have belonged to his wife. This transfer of the dead woman's possessions to the woman he had been courting under false pretences became one of the central pieces of circumstantial evidence considered by the court, and it was a fact that Herbert Bennett did not dispute, though he offered an account of how the items had come into his possession that differed from the account advanced by the prosecution. Herbert Bennett was arrested approximately 7 weeks after the death of his wife, placing his arrest in the middle of November 1900. The specific circumstances of his arrest, including the exact date, the location, and the details of his initial statements to police, are not established with precision in the sources reviewed for this account, and this account does not attempt to reconstruct dialogue or interrogation detail that the surviving record does not support. What is established is that the 7-week interval between the death of Mary Jane Bennett and the arrest of her husband was occupied by an investigation that began with the difficulty of identifying a woman who had died under a false name, and that this investigation, once it had established Herbert Bennett's identity and connection to the deceased, proceeded to his arrest and, in time, to his committal for trial. At trial, Herbert Bennett was defended by Edward Marshall Hall, a barrister who by 1900 had already established himself as one of the most capable advocates practicing at the English criminal bar. Marshall Hall's involvement in the case ensured that the defence presented at the Old Bailey was conducted with considerable skill, and the alibi evidence he presented on his client's behalf, drawn substantially from the testimony of a witness, Sholto Douglas, placing Herbert Bennett in Bexley after the last train to Great Yarmouth had departed, would later be characterised by writers examining the case as evidence that left genuine and substantial doubt as to his guilt. Herbert Bennett himself denied the killing of his wife, throughout the investigation, throughout his trial, and, according to the accounts that have survived concerning his final days, to the very end of his life, he offered no confession at any stage of the proceedings against him. Mary Jane Bennett was found dead upon the south beach of Great Yarmouth, in the area known as the South Deniers, a stretch of open shoreline to the south of the town's main promenade and harbour mouth, used in this period as much by working fishermen and the labouring population of the town as by holiday makers. The cause of her death was established as asphyxia, brought about by strangulation with a ligature, specifically a mohair bootlace, which had been drawn tight about her throat and knotted there. This account will not itemise further clinical detail concerning the nature of the injury. It is sufficient to record that the ligature had ended her life by asphyxiation, and that the cause of death, once established, was not itself a matter of dispute in the subsequent proceedings, the contested elements of the case lying elsewhere, in the evidence connecting a particular individual to the act. No witnesses to the killing itself are recorded in the surviving sources. Mary Jane Bennett was last known to have been alive in the days immediately preceding her death. Resident in her lodgings in the Rows under the name Mrs. Hood, and her body was discovered on the beach on the morning following her death, placing the discovery in the final days of September 1900. The surviving sources are not entirely consistent as to whether this discovery occurred on the 22nd or the 23rd of September, and this account does not resolve that discrepancy beyond noting that the body was found in the final days of that month, upon the open beach in a location that afforded no shelter and little concealment from the ordinary traffic of the shore. The discovery of Mary Jane Bennett's body on the south beach of Great Yarmouth set in motion an investigation that would, within a matter of weeks, extend well beyond the boundaries of the Norfolk resort town in which she had died. The initial response to the discovery fell to the Great Yarmouth Borough Police, the force with jurisdiction over the town and its immediate shoreline. Officers were dispatched to the beach to examine the position of the body and to secure the surrounding area, in keeping with the ordinary procedure followed in cases of sudden and violent death discovered in a public place. The identity of the individual who first came upon the body on the morning it was found is not established with confidence in the sources reviewed for this account, and no name is supplied here where the record does not support one. The most immediate obstacle facing the investigating officers was the question of identity. The dead woman had been known in her lodgings only as Mrs. Hood, a name under which she had presented herself to her landlady and to the wider community of the Rows, and nothing found upon her person or among her effects in the lodging house offered an obvious means of establishing who she actually was. This difficulty was not unusual in cases involving visitors to a seasonal resort town, where landladies were accustomed to accepting lodgers on the strength of a name and the promise of rent, with little inquiry made into a stranger's background or origins. The investigating officers were, in consequence, obliged to proceed from the physical evidence available to them, examining the clothing and possessions left behind in the lodgings for any mark or feature that might assist in establishing the dead woman's true identity. It was through this examination of her clothing that the investigation achieved its first significant breakthrough. A laundry mark was discovered upon one or more items belonging to the dead woman, a mark of the kind commonly applied by commercial laundries in this period to distinguish one customer's garments from another's during the process of washing and returning large quantities of linen. Officers traced this laundry mark to a specific laundry business operating in the London area, and through the records maintained by that laundry, they were able to establish the name and address of the customer to whom the marked garments belonged. This inquiry led investigators to the name of Mary Bennett, resident in the Bexleyheath district, and from this identification, the investigation acquired both a name for the dead woman and, in short order, a connection to her husband, Herbert John Bennett. The establishment of Mary Jane Bennett's identity transformed the character of the inquiry considerably. What had begun as an investigation into an unidentified woman found dead upon a public beach under an assumed name now became an inquiry into the household and associations of a married woman from the London suburbs, a woman whose husband could be traced, interviewed, and, in time, examined as to his own movements during the period in question. Officers proceeded to make inquiries of Herbert Bennett and of those who knew him, seeking to establish his whereabouts during the days surrounding his wife's death and his knowledge of her presence in Great Yarmouth under a false name. A further and significant line of inquiry concerned a gold watch and chain that Mary Jane Bennett had been photographed wearing during her stay in Great Yarmouth, an item of jewellery captured in an image taken on the beach in the days before her death. This watch and chain were found to be missing from her possessions following her death, and investigators subsequently established that jewellery of a similar description had come into the possession of Herbert Bennett's London room, along with articles of clothing that were later identified as having belonged to the dead woman. These items, it emerged, had in turn been passed by Herbert Bennett to Alice Meadows, the young woman he had been courting under the pretence of being unmarried. The presence of the dead woman's jewellery and clothing in the hands of her husband's other romantic interest formed one of the most significant circumstantial threads pursued by the investigating officers, and it would remain central to the case as it proceeded toward trial. Statements were taken from those connected to the household in Bexleyheath, from associates of Herbert Bennett and from Alice Meadows herself, regarding the circumstances under which she had received the items later identified as belonging to Mary Jane Bennett. Alice Meadows, according to the established record, had understood Herbert Bennett to be an unmarried man throughout the period of their courtship, and her statements to investigators would have addressed the circumstances of the gift she received from him, though the specific content of her testimony, as given to police in the initial stages of the inquiry, is not detailed with precision in the sources reviewed for this account. The investigation also required officers to establish, so far as the surviving records allowed, the movements of Herbert Bennett in the days surrounding his wife's death, a task complicated by his employment at or connection with the Woolwich Arsenal, an institution that maintained its own detailed attendance and wage records. These records would, in time, become the central evidentiary battleground of the case, cited by the defence as evidence placing Herbert Bennett in London on the material day, and thus incompatible with the prosecution's contention that he had travelled to Great Yarmouth to kill his wife. The investigating officers, for their part, pursued the case on the theory that Herbert Bennett had made the journey to Norfolk despite these records, and the reconciliation of this apparent conflict between attendance records and the prosecution's timeline would occupy a significant portion of the subsequent trial. Approximately 7 weeks elapsed between the discovery of Mary Jane Bennett's body and the arrest of her husband, a period occupied by the identification of the victim, the tracing of the laundry mark, the establishment of the connection to Herbert Bennett, and the gathering of statements and physical evidence connecting him to his wife's possessions. Herbert Bennett was arrested in the middle of November 1900, and following his arrest, the case proceeded toward committal proceedings that would determine whether sufficient evidence existed to send him for trial at the Old Bailey. The circumstantial nature of the evidence assembled during this investigation, resting as it did upon a laundry mark, a missing watch and chain, items of clothing and jewellery traced to a second woman, and the disputed question of Herbert Bennett's whereabouts on the day, meant that the case that emerged from this 7-week inquiry was one built entirely upon inference and circumstance, without direct witness testimony to the killing itself. The investigation into Mary Jane Bennett's death may be summarised as one proceeding from an initial obstacle of unidentified death to a resolution achieved through the patient tracing of a single physical clue, the laundry mark, which in turn opened a chain of inquiry into a household, a marriage, and a second relationship conducted under false pretenses. No witness came forward who had observed the killing, and the case against Herbert Bennett rested, from its earliest stages, upon the circumstantial connections established between the dead woman's possessions, her husband's movements, and the woman to whom he had given items that had belonged to his wife. This circumstantial foundation would remain the defining feature of the case as it moved from investigation to trial. A post-mortem examination of Mary Jane Bennett's body was conducted in the days following its discovery, undertaken in order to establish formally the cause of death and to record such findings as would assist the coroner and, in due course, the court. The examining physician's name is not established with confidence in the sources reviewed for this account, and this narration does not attempt to supply one. The examination confirmed that death had resulted from asphyxia, caused by the mohair bootlace drawn tightly about the throat and secured there by a knot, a finding consistent with the condition in which the body had been discovered upon the beach. The examination further indicated that death had occurred rapidly, and that the injury responsible was such as to leave no reasonable doubt as to the cause. No further clinical detail concerning the condition of the body was drawn upon in the case as it proceeded, the medical evidence remaining throughout the subsequent inquiry and trial a matter of comparatively little dispute. The contested elements of the case lay not in the manner of death but in the question of who had been responsible for it, and the physician's findings were treated by both prosecution and defence as an established foundation upon which the remainder of the case would be built. The physician's examination also addressed the approximate time that had elapsed between death and discovery, a determination assisted by the condition of the body when found, and by the fact that Mary Jane Bennett had last been seen alive in her lodgings in the Rows in the days immediately preceding the discovery. This determination allowed investigators to narrow the period during which the killing must have occurred, and it was against this narrowed window that the subsequent inquiry into Herbert Bennett's movements and the alibi testimony that would later be cited in his defence came to be measured. The post-mortem findings, once recorded, were communicated to the coroner appointed to conduct the inquest into Mary Jane Bennett's death, and it was before this coroner that the first formal public airing of the case would take place. An inquest was convened before the coroner at Great Yarmouth in the days following the discovery of the body, in keeping with the ordinary legal requirement that any sudden or violent death be examined by a coroner's jury before the case could proceed further through the courts. The specific name of the coroner who presided and the exact wording of the verdict returned are not established with confidence in the sources reviewed for this account. What is established is that the inquest proceeded on the basis of the medical evidence already gathered, together with such testimony as could be offered regarding the discovery of the body and the identification of the deceased through the laundry mark traced to her clothing. The coroner's jury heard evidence establishing that the woman known in her lodgings as Mrs. Hood was in fact Mary Jane Bennett of Bexleyheath, and that she had died as a result of strangulation by ligature upon the south beach of the town. The proceedings before the coroner were necessarily limited in scope at this early stage of the investigation, since the connection between the dead woman and her husband had only recently been established through the tracing of the laundry mark, and the fuller, circumstantial case against Herbert Bennett, resting upon the missing watch and chain and the items later found in the possession of Alice Meadows, was still being assembled by investigating officers even as the inquest proceeded. The inquest served in this sense chiefly to formalise the facts of identity and cause of death, clearing the way for the criminal investigation to continue toward a decision on whether any individual should be charged in connection with the death. The coroner's proceedings concluded with the matter being left open for further police inquiry, pending the completion of the wider investigation into Herbert Bennett's movements and associations. Following the conclusion of the coroner's proceedings and the completion of the police investigation that led to the arrest of Herbert Bennett in the middle of November, the case proceeded to committal proceedings before a magistrate at which the evidence gathered by police was presented in order to determine whether it was sufficient to send Herbert Bennett for trial on a charge of willful murder. The magistrate, having heard the evidence relating to the laundry mark, the missing jewellery, the items given to Alice Meadows, and such evidence as had been gathered regarding Herbert Bennett's movements in September, determined that the case should proceed to trial, and Herbert Bennett was committed to stand trial at the Central Criminal Court, the Old Bailey, in London. The choice of the Old Bailey as the venue for the trial, rather than the Norfolk assizes that would ordinarily have heard a case arising from a death within that county, reflected the particular circumstances of the case, in which the accused was domiciled in London, and much of the evidence connecting him to the crime, including the alibi testimony and the evidence of Alice Meadows, arose from his London life, rather than from anything observed in Great Yarmouth itself. The cross-jurisdictional character of the case, spanning a death in Norfolk and an accused man resident and employed in the London suburbs, was itself a distinctive feature of the proceedings, requiring witnesses and evidence to be drawn from both locations for presentation before a single court. The trial of Herbert John Bennett commenced at the Old Bailey in February 1901 and continued across 5 days of proceedings, a duration considered substantial for a capital trial of this period. The prosecution opened its case by setting out the circumstances of Mary Jane Bennett's death upon the beach at Great Yarmouth, the discovery of her body, and the subsequent identification achieved through the laundry mark traced to her clothing. The prosecution then proceeded to lay before the court the theory that Herbert Bennett had arranged for his wife and daughter to take lodgings in Great Yarmouth under a false name, and that he had subsequently travelled to the town for the purpose of killing her, motivated by his relationship with Alice Meadows and by a desire to be free of his marriage. In support of this theory, the prosecution presented evidence concerning the missing watch and chain, the items of clothing and jewellery found in Herbert Bennett's possession and subsequently given to Alice Meadows, and such evidence as could be offered regarding his movements during the period surrounding his wife's death. The defence, conducted by Edward Marshall Hall, presented in response a case built substantially upon the attendance and wage records maintained by the Woolwich Arsenal, records that were said to place Herbert Bennett at his place of employment in London on the day upon which the prosecution alleged he had travelled to Great Yarmouth to kill his wife. These records, maintained by the Arsenal as a matter of routine administrative practice, rather than for any purpose connected with this case, were presented to the court as an objective and disinterested form of evidence, difficult to reconcile with the prosecution's account of Herbert Bennett's presence in Norfolk on the material day. The defence further presented the testimony of at least one witness, placing Herbert Bennett in London during the relevant period, adding a further layer of evidence in support of the contention that he could not have been in Great Yarmouth at the time his wife was killed. The prosecution, for its part, sought to address this alibi evidence by arguing that Douglas's testimony was mistaken or unreliable as to timing, and by continuing to emphasise the circumstantial weight of the missing jewellery and the items passed to Alice Meadows as evidence of Herbert Bennett's guilt, regardless of the precise timing of his movements. The presentation of Alice Meadows' own testimony before the court, describing her understanding that Herbert Bennett was an unmarried man and detailing the circumstances under which she had received items later identified as belonging to Mary Jane Bennett, formed a significant portion of the prosecution's case, presented as evidence both of motive and of the disposal of the dead woman's property. Over the course of the 5 days of proceedings, the court heard extensive testimony concerning the laundry mark and the process by which it had led investigators to identify the dead woman, the condition in which her body had been found upon the beach, the medical evidence establishing asphyxia by ligature as the cause of death, and the chain of circumstantial evidence connecting Herbert Bennett to his wife's missing possessions. The defence maintained throughout that this circumstantial evidence, however extensive, did not overcome the alibi established through Douglas's testimony, and Marshal Hall's closing address to the jury emphasised this alibi evidence as a form of proof superior to inference drawn from the disposal of jewellery and clothing. Following the conclusion of the evidence and the closing addresses of counsel for both prosecution and defence, the judge delivered his summation to the jury, reviewing the evidence presented over the preceding 5 days and directing the jury as to the law applicable to a charge of willful murder. The jury then retired to consider its verdict. The jury's deliberation lasted approximately 35 minutes, a period that later commentators examining the case would characterise as strikingly brief given the volume and complexity of the evidence presented, including the substantial alibi evidence drawn from Douglas's testimony. At the conclusion of this brief deliberation, the jury returned a verdict of guilty. Herbert Bennett was accordingly convicted of the willful murder of his wife, Mary Jane Bennett, on the basis of the circumstantial case presented by the prosecution, notwithstanding the alibi evidence presented by the defence. The trial of Herbert Bennett may be summarised, in its essential character, as a case decided upon circumstantial evidence, resting upon the disposal of a dead woman's jewellery and clothing to another woman, set against an alibi drawn from the testimony of a defence witness placing Herbert Bennett in Bexley after the last train to Great Yarmouth had departed. The speed of the jury's verdict, returned in barely half an hour, despite the presentation of this substantial and documented alibi evidence, would remain one of the most closely examined features of the case in the years that followed, cited repeatedly by those who came to question whether the verdict returned at the Old Bailey in February 1901 had, in fact, been the correct one. Following the return of the guilty verdict, the court proceeded to sentencing. Under the law, then in force, a conviction for willful murder carried a single mandatory sentence, and the judge accordingly pronounced sentence of death upon Herbert Bennett, in keeping with the established procedure of the period. The pronouncement of sentence in a capital case at this time followed a fixed form, the judge donning the black cap customarily associated with such pronouncements before delivering the sentence of the court, and the record establishes that this sentence was duly passed upon Herbert Bennett at the conclusion of his trial in February 1901. Whether any petition for clemency was subsequently submitted to the Home Secretary on his behalf is not established with confidence in the sources reviewed for this account, and this narration does not assert that such a petition was or was not filed. The period between sentencing and execution in cases of this kind was customarily occupied by the condemned prisoner's removal to the prison at which the sentence was to be carried out, together with such visits, correspondence, and religious attendance as the prison authorities permitted under the regulations then governing the treatment of condemned persons. Herbert Bennett was removed to Norwich Prison to await the carrying out of his sentence, and it was at Norwich, rather than at the scene of the crime in Great Yarmouth, or at the London court in which he had been tried, that the final stage of the case would be enacted. Throughout this period, Herbert Bennett continued to maintain his innocence of the killing of his wife, a position from which the surviving record indicates he did not depart at any point between his arrest and his death. Herbert John Bennett was hanged at Norwich Prison on the 21st of March 1901, a date falling within the first weeks of the reign of Edward VII, Queen Victoria having died on the 22nd of January of that year, some 5 weeks before the trial itself had commenced. The killing of Mary Jane Bennett, occurring as it had in September of 1900, fell within the final months of the old Queen's reign, while the trial, conviction, and execution of her husband took place in the opening weeks of the new one, a circumstance that placed the case at the precise hinge between two reigns, its origin belonging to one era and its legal conclusion to another. The execution was carried out according to the established procedure of the period, before witnesses required by law to be present, and marked by the customary raising of a black flag over the prison to signal to those gathered outside its walls that the sentence had been carried into effect. It was at this moment, according to the accounts that have been preserved of the occasion, that the flagpole above Norwich Prison snapped, so that the black flag intended to announce the completion of the execution failed to rise in the customary manner. This detail, recorded by those present and repeated in subsequent accounts of the case, was received at the time and in the years that followed as an omen by those inclined to read significance into such occurrences, understood by some among the watching public as a sign that the man who had just been hanged had not in fact been guilty of the crime for which he died. This account records the incident as it was reported and received, a piece of testimony belonging to the case's contemporary reception, without asserting that the breaking of a flagpole carries any evidentiary weight as to guilt or innocence. Herbert Bennett denied the killing of his wife, to the last according to the accounts that have survived of his final days at Norwich Prison, maintaining the position he had held since his arrest some 4 months earlier. The specific wording of any final statement attributed to him at the scaffold is not established with sufficient confidence in the sources reviewed for this account to be repeated here as verified fact, and this narration does not invent or supply such a statement. What can be recorded with confidence is that no confession was ever obtained from him, at any stage between his arrest in November of 1900 and his death in March of 1901, and that he went to his execution maintaining the same denial he had offered from the outset. The conviction of Herbert Bennett has never been the subject of a formal pardon or legal exoneration. No court has set aside the verdict returned at the Old Bailey in February 1901, and the historical record, as it stands, continues to reflect a conviction that was never overturned through any subsequent legal process. The case is nonetheless the subject of enduring and substantial doubt, a doubt rooted chiefly in the brevity of the jury's deliberation, lasting barely half an hour, set against the alibi evidence drawn from the testimony of a defence witness placing Herbert Bennett in Bexley after the last train to Great Yarmouth had departed. This doubt has not diminished with the passage of more than a century. In the year 2025, a descendant of Herbert Bennett, a great-grandson, brought renewed public attention to the case through a campaign seeking to have the conviction reassessed, drawing on the same body of alibi evidence presented at the original trial and arguing that the evidence relied upon by the prosecution had been, in the description offered by one contemporary retrospective account, comparatively flimsy when weighed against it. This campaign, as of the present time, has not resulted in any formal reversal of the conviction, and the case remains, in the fullest sense, unresolved. It stands convicted in law and doubted in history, a case in which a man was tried, found guilty in half an hour, and hanged, while the alibi testimony placed before the jury continued, in the view of those who have examined the case since, to raise a real and unanswered question as to whether the verdict was correct. The case of Herbert and Mary Jane Bennett entered the published record within a few years of the execution, appearing among the volumes devoted to notable British trials that collected verbatim transcripts and commentary on cases considered to be of lasting public interest, a form of publication reserved for trials judged to hold significance beyond their own immediate circumstances. This volume preserved the proceedings of the 5 days at the Old Bailey in a level of detail not typically afforded to cases of lesser prominence, ensuring that the evidence presented by both prosecution and defence, including the alibi testimony at the centre of the defence case, remained available for examination by later generations of readers and researchers. The case received further treatment in more recent years through a work of popular history published in the 2020s, offering a modern narrative account of the events surrounding Mary Jane Bennett's death and the trial that followed, drawing together the surviving documentary sources into a continuous retelling for a contemporary readership. Beyond this volume, the case has continued to attract the attention of local historians in Great Yarmouth itself, where retrospective newspaper features have periodically revisited the events of September 1900 as among the most notorious episodes in the town's history, and it has been discussed within the broader genre of podcast programs devoted to historical true crime, several of which have drawn a connection between the killing of Mary Jane Bennett upon the South Beach and a second, unrelated strangling that occurred upon the same stretch of shore some 12 years later in 1912. This later case, involving a young woman named Dora Gray, remains unsolved to the present day, and it belongs to the Edwardian period rather than to the Victorian era with which this account is concerned. It is noted here only because the two cases share a location and, in general terms, a method, a fact that has led some later writers to draw the two together in discussion of Great Yarmouth's history of violent crime upon its beach. The 1912 case was never connected to Herbert Bennett, who had been dead for more than a decade by the time it occurred, and it was never solved, no suspect having been identified or charged in connection with it. It stands as a separate and unrelated episode in the town's history, distinct in every particular from the case of Mary Jane Bennett, save for the accident of shared geography. The historical legacy of the case rests in the fullest sense upon its unusual character as a fully tried, fully concluded capital case that nonetheless continues to generate active historical dispute more than a century after its resolution. Most cases that later come to be regarded as possible miscarriages of justice from the Victorian and Edwardian periods have long since been examined exhaustively by generations of legal historians, their evidentiary weaknesses catalogued and their disputed facts thoroughly aired. The case of Herbert Bennett, by contrast, retains sufficient obscurity for over a century that a direct descendant in the year 2025 could still bring what was described as new public attention to the documentary alibi evidence at its centre, arguing that the case deserved formal reassessment. This combination of a fully executed sentence and a genuinely live campaign for reconsideration, occurring more than 120 years after the original trial, distinguishes the case within the broader landscape of contested Victorian and Edwardian convictions. Great Yarmouth itself, in the years following 1901, retained the case as one of the defining episodes of violent crime in its modern history, a status reinforced by the town's continued association with the beach on which Mary Jane Bennett died, and later with the unrelated killing of Dora Gray in 1912. The Rose in which Mary Jane Bennett had taken her lodgings under the false name Mrs. Hood continued to serve their traditional function as cheap seasonal accommodation for some decades after her death, before large sections of this historic network of alleyways were destroyed during aerial bombardment in the 20th century, a loss that removed much of the physical fabric within which the opening days of the case had unfolded, though the surviving sections and the historical record of the district continue to anchor the case within a specific and identifiable place. The broader social context of the case reflects the particular conditions of a seaside resort economy at the close of the 19th century, in which landladies routinely accepted lodgers on the strength of a stated name and the promise of rent, without inquiry into a stranger's true circumstances, a practice that allowed Mary Jane Bennett to take residence for over a week under an assumed identity without occasioning comment or suspicion. It reflects equally the particular evidentiary weight that a credible alibi witness could carry against a case built on circumstantial inference, the testimony of Sholto Douglas placing Herbert Bennett in Bexley after the last train to Great Yarmouth being treated by the defence and by later commentators as difficult to reconcile with the prosecution's account of his movements. The case was entered into the historical record. It has remained there. The verdict stood. The case became part of British memory. That is where the record of the first case ends. We turn now to a second account, quieter than the one before it, and far less remembered, one that unfolded in a different corner of the same city, in a year when an entire district still held its collective memory of an unsolved series of killings close, and any fresh act of violence against a woman in its streets was measured immediately against that memory. What follows turns upon a question that was disputed at the time and has never been settled since. The case of Alice Mackenzie begins in Whitechapel, in the London borough of Tower Hamlets, in July of 1889. Whitechapel at this date was one of the most densely populated districts in the capital, a warren of narrow streets, courts and alleys, pressed between the commercial thoroughfares of Whitechapel High Street and Commercial Street, housing a population numbering in the tens of thousands within a comparatively small area. The district's economy rested on casual and seasonal labour, market trading, small workshops, and the docks that lay within walking distance to the south, and a substantial proportion of its residents moved frequently between addresses, taking lodgings by the night rather than by the week or the month. Common lodging houses formed the backbone of housing for the poorest residents of the district, offering a bed for a fee collected each evening, in rooms shared among strangers and acquaintances alike. Gun Street, running through the heart of this network of lodging houses, was one such address, and it was here that Alice Mackenzie had been living for a period preceding her death, in the company of a porter named John McCormack, with whom she had maintained a domestic arrangement of some duration. The exact length of that arrangement is not established in the surviving record, but McCormack and Mackenzie were known to the keepers and residents of the lodging houses along Gun Street as a settled couple, sharing a room and, by report, a degree of mutual support common among residents in their circumstances. Mackenzie herself was known in the neighbourhood by a nickname, Claypipe Alice, given to her for her habit of smoking a clay pipe, a detail recorded consistently enough across contemporary accounts to be treated as established fact. She was approximately 40 years of age at the time of her death. Her name appears in the historical record under more than one spelling, Mackenzie and Mackenzie, both being used interchangeably in contemporary documents, and this account uses the former throughout for consistency. She was also known by the name Alice Pitts in at least one account. Her partner John McCormack was likewise known by the alternative surname Bryant, though the circumstances under which these alternative names were used are not established with certainty. Her origins, her birthplace, and the identity of her parents are not documented in any source available for this account. What can be said is that by the summer of 1889, she was a fixture of the Gun Street lodging houses, known to her neighbours, known to the keepers of the houses in which she stayed, and known, at least by sight, to the constables whose beats carried them through the surrounding streets. The district in which she lived had, by July of 1889, spent nearly a full year under the shadow of an unresolved series of murders committed in its streets and courts during the autumn of the previous year. Those murders remained unsolved. No arrest had been made that satisfied the public or the press, and the sense of vulnerability they had produced among the women of the district, particularly among those without stable housing or a settled means of income, had not fully receded by the time of the events considered in this account. Newspapers continued to report on the district in terms shaped by that earlier series, and residents continued to describe an atmosphere of watchfulness that had become, by mid-1889, a persistent feature of daily life in Whitechapel, rather than a passing alarm. The constabulary maintained an active presence in the district throughout this period, with officers of H Division, the Metropolitan Police Division responsible for Whitechapel, walking fixed beats through the streets and alleys at intervals through the night. Castle Alley, a narrow passage connecting to Whitechapel High Street, lay within the patrol route of these officers, as did the surrounding network of courts and yards that characterised the area. The alley was poorly lit, as were most of the district's smaller thoroughfares, illuminated only by such gas lighting as had been installed at wider intervals along the main streets. leaving many of the narrower passages in near darkness during the hours after midnight. Alice Mackenzie's precise movements on the evening preceding her death, and in the hours before her body was discovered, are not documented in the sources available for this account. What she did that evening, whom she saw, and where she had been before entering Castle Alley are matters on which the surviving record is silent. Her means of livelihood at the time of her death is recorded in the inquest testimony, which described her as working as a washerwoman and charwoman for local Jewish residents. The lodging house economy of Whitechapel supported its residents through a range of occupations, casual labour, market work, and other means. And while some women in circumstances similar to Mackenzie's supported themselves, in part through itinerant sex work, no source specific to Mackenzie's own activities on the night in question establishes this as fact in her case, and this account does not present it as established. What is established is that, in the early hours of the 17th of July, 1889, Alice Mackenzie was found dead in Castle Alley. The discovery was made by a police constable named Walter Andrews in the course of his regular beat patrol through the district, at approximately 12 minutes before 1 o'clock in the morning. Andrews had passed through the alley on an earlier circuit of his beat without incident, and it was on his return that he came upon the body. He raised the alarm immediately, and other officers were summoned to the scene within a short time. The body was found to bear injuries to the throat, consistent with a cutting implement, and it was these injuries that were determined to have caused her death. The wounds to the throat were, by the assessment of the physicians, who subsequently examined the body, less severe in extent than those inflicted upon the victims of the murders committed in the district during the previous year. Additional injuries were noted to the abdomen, described as superficial in character, suggesting an attempt at further mutilation that had not been carried through to the extent seen in the earlier series. No further detail as to the nature or extent of these injuries is given in this account, beyond what is necessary to establish the cause of death and the character of the assault, in keeping with the restraint appropriate to a case of this kind. No witnesses to the attack itself have been identified in the surviving record. The alley in which Mackenzie was found was not, at the hour in question, a place in which passers-by would ordinarily have been present in number, and the darkness of the passage would have limited visibility considerably even had witnesses been nearby. Constable Andrews, upon discovering the body, summoned assistance, and the alarm was passed through the usual channels to the divisional police station and to the officers responsible for the investigation of serious crime within the district. The response to the discovery was immediate and, given the district's recent history, attended by a degree of scrutiny beyond what would ordinarily have accompanied the discovery of a body in these circumstances. Senior officers of the Metropolitan Police were notified without delay, and the scene in Castle Alley was examined by police surgeons attached to the division, as well as by at least one physician called in specifically for his familiarity with the earlier series of murders. The case was, from its earliest hours, considered in direct relation to the unresolved murders of 1888, both by the investigating officers and by the press that reported on the discovery. The investigation that followed proceeded along lines that had become established practice for the division in the aftermath of the previous year's murders. Officers were dispatched to conduct inquiries among the residents of the lodging houses in the immediate vicinity of Castle Alley and Gun Street, seeking any information as to Mackenzie's movements in the hours before her death, and as to any persons seen in the area of the alley during the relevant period. The keepers of the lodging houses were questioned as to who had been present on the premises that night, and as to any unfamiliar persons who might have been seen in the vicinity. John McCormick, as Mackenzie's domestic partner, was among those questioned in the course of these inquiries, though the specific content of his statement to police is not detailed in the surviving record. The constables of H Division, who had been on duty in the district that night, were required to account for their movements and observations during their respective beats, a standard step in any investigation of this kind, intended to establish the sequence of events preceding the discovery and to identify any officer who might have observed a person entering or leaving the vicinity of Castle Alley in the relevant period. Constable Andrews' own account of his patrol, including the interval between his two passes through the alley, formed a central element of the timeline established by investigators in the days following the discovery. Detectives attached to the investigation undertook a wider canvass of the surrounding streets, seeking any resident, trader, or passerby who might have seen or heard anything of relevance in the hours before Mackenzie's body was found. The lodging houses of Gun Street and the neighbouring courts housed a large and frequently changing population, and the task of identifying and interviewing all those who might have relevant information required a sustained effort over the days that followed. The results of this canvass, in terms of any specific information gathered, are not detailed in the sources available for this account, beyond the general fact that no suspect was identified through these inquiries. The investigation proceeded under conditions of considerable public and press attention, given the immediate association drawn between this case and the unresolved murders of the previous year. Reports of the discovery appeared in the London newspapers within hours, and the question of whether the same individual responsible for the 1888 murders had committed this act was raised publicly from the earliest stage of the investigation. This question shaped both the conduct of the investigation and the manner in which its findings were subsequently reported, with officers and physicians alike required to address it directly in their assessments of the case. Two police surgeons in particular were called upon to offer their professional opinion as to the relationship between this case and the earlier series. Dr. George Bagster Phillips, the divisional police surgeon for the district, who had himself examined the remains of several victims of the 1888 murders, examined Mackenzie's body and formed the view that the injuries inflicted upon her differed in character and method from those of the earlier series, leading him to doubt that the same hand was responsible. Dr. Thomas Bond, who had likewise been consulted during the investigation of the 1888 murders and had submitted a comparative assessment of that series at the time, was asked to offer a further opinion on this case and concluded, contrary to Phillips, that the injuries were consistent with the same perpetrator having committed both this act and the earlier murders. This disagreement between the two physicians was not resolved during the course of the investigation, and it has not been resolved since. It represents one of the central points of dispute in the historical treatment of this case, and it is presented here as it stood at the time, an open disagreement between two named professionals of standing within their field, rather than as a question with a settled answer. No further physician's assessment is documented in the available sources as having reconciled the two positions, and the question of whether Alice Mackenzie was a victim of the individual responsible for the 1888 Whitechapel murders remains on the surviving record undetermined. An inquest into the death of Alice Mackenzie was convened before Wynne Baxter, the coroner for the Eastern Division of the County of London, the same coroner who had presided over the inquests into several of the murders committed in the district the previous year. The inquest was opened within days of the discovery, in accordance with the ordinary procedure governing sudden and violent deaths within the coroner's jurisdiction, and was attended by representatives of the Metropolitan Police alongside the witnesses called to give evidence of the circumstances of the discovery and the findings of the medical examination. Constable Andrews was called to give an account of his discovery of the body, describing the timing of his beat and the condition in which he found her in Castle Alley. The physicians who had examined the body were called in turn to present their findings as to the cause of death and the nature of the injuries sustained, and it was in the course of this testimony that the disagreement between Phillips and Bond as to the relationship between this case and the murders of the previous year was placed before the coroner and the jury. Other witnesses, drawn from among the residents of the lodging houses and the immediate neighbourhood, were called to give what account they could of Mackenzie's circumstances and of any observations relevant to the hours preceding her death, though the specific content of their testimony, beyond what has already been described, is not preserved in full in the sources available for this account. The jury retired to consider the evidence placed before it, in keeping with the ordinary procedure of a coroner's inquest, weighing the testimony of the constable, the physicians, and the other witnesses called before reaching its determination. The verdict returned was one of willful murder against some person or persons unknown, the form ordinarily returned by a coroner's jury in cases where a death by violence has been established, but no individual has been identified as responsible. The precise wording recorded in the inquest documents themselves has not survived in a form available to this account, and this description should be understood as reflecting the standard and expected form for a verdict of this kind, rather than a verbatim transcription of the coroner's record. With the inquest concluded and no suspect identified, the investigation continued under the direction of the Metropolitan Police, but without result. No individual was ever brought before a magistrate in connection with the death of Alice Mackenzie, and no trial of any kind followed from the inquiries conducted in the weeks after her death. The case remained, from the point of the inquest's conclusion onward, a matter of continuing investigation without resolution, its file retained by the police alongside the unresolved files of the murders committed in the district the previous year, to which it continued to be compared in both official and public discussion. The absence of any arrest in this case, following so closely upon the unresolved murders of 1888, was received by the public and by the press as a further indication of the failure of the Metropolitan Police to bring the perpetrator or perpetrators of violence against women in the district to justice. Newspaper commentary in the weeks following Mackenzie's death continued to press the question of whether a single individual remained at large in Whitechapel responsible for this death as well as those of the previous year, and the police were subject to renewed criticism over their inability to resolve either question. The pressure exerted upon the division in this period was considerable, and it shaped both the conduct of subsequent patrols through the district and the continuing allocation of officers to inquiries connected with the case. John McCormack's life in the period following Mackenzie's death is not documented in the sources available for this account. The lodging house on Gun Street, in which the two had lived together, continued to operate as before, one address among many in a district where such houses provided shelter to a population in near constant movement, and no further record of McCormack's circumstances following the loss of his companion has been preserved in a form accessible to this account. The case of Alice Mackenzie has been preserved chiefly within the specialist literature devoted to the study of the Whitechapel murders of 1888, appearing as one of a number of deaths considered by later researchers in connection with that earlier series, sometimes included within the broader designation of the Whitechapel murders and sometimes treated as a separate and unrelated act of violence. It has not, on its own account, attracted the attention of playwrights, novelists, or filmmakers in the manner of certain other cases from the period, and its documentation rests primarily upon archival and reference material devoted to the study of the district's history during these years, rather than upon any independent tradition of dramatic or literary treatment. Reference works devoted to the study of the 1888 murders continue to record her case as one of the disputed questions arising from that period, citing the divided opinion of Phillips and Bond as evidence of the genuine uncertainty that attended the question in its own time. The uncertainty surrounding the identity of the perpetrator, and the question of whether Alice Mackenzie should properly be counted among the victims of the individual responsible for the murders of 1888, has remained a matter of continuing discussion among those who have studied the case in the years since. No consensus has been reached. The disagreement recorded between the two examining physicians at the time has been treated by later researchers as a central piece of evidence in this ongoing discussion, cited on both sides of the question, without either position having been conclusively established over the other. The district in which Alice Mackenzie lived and died continued, through the remaining years of the 19th century, to bear the character that had shaped her own circumstances. A place of dense population, casual labour and transient housing, in which women without stable income or settled residence remained particularly exposed to violence that, in a great many instances, went unresolved. The lodging houses of Gun Street and the surrounding streets continued to house a shifting population of residents through these years, and the memory of the murders of 1888, together with the death of Alice Mackenzie the following summer, remained a persistent element of the district's own understanding of itself for years afterward. The lodging houses that lined Gun Street and the courts running off it operated on a strict nightly economy. A fee collected each evening at the door before a bed for the night was granted, with no obligation upon the keeper or the lodger beyond that single transaction. A house of this kind might accommodate several dozen people in a single night. Men and women housed in separate wards, according to the practice of the establishment, sharing kitchens and common rooms in which meals were prepared and consumed communally. Alice Mackenzie's residence in such a house, alongside John McCormack, placed her within a population that changed in its particulars from night to night, even as the general character of the street remained constant, a population bound together, less by long acquaintance than by shared circumstance and shared address. The keepers of these houses were required, under the licensing arrangements then in force for common lodging houses within the metropolis, to maintain a register of those who stayed under their roof. And it was to these registers that police inquiries turned in the days following Mackenzie's death, seeking the names of those who had shared the house with her and with McCormack, and seeking any account of her movements on the evening before her body was found. The registers themselves and any information drawn from them beyond what has already been described are not preserved in a form available to this account, though their existence as a standard instrument of the investigation is well established. The pressure exerted upon the Metropolitan Police in the weeks following the discovery in Castle Alley extended beyond newspaper commentary into more formal channels of scrutiny. Questions concerning the adequacy of policing in Whitechapel and concerning the continued failure to resolve the murders of the preceding year were raised in this period through the ordinary channels by which the conduct of the Metropolitan Police was held to account, and the division's officers were required to respond to this scrutiny even as they continued their inquiries into Mackenzie's death. The effect of this pressure was to sustain a heightened level of police activity within the district for a period following the discovery, with officers assigned in greater number to patrol duties through Castle Alley and the surrounding streets during the hours of darkness, in a manner intended to reassure residents and to deter any further act of violence. This heightened patrol activity did not, on the surviving record, produce any additional evidence bearing upon the identity of the person responsible for Mackenzie's death, and the investigation, notwithstanding the resources committed to it, did not advance beyond the position reached in its earliest days. The division's registers of unresolved deaths among women in the district during this period were not limited to the murders of 1888 and the death of Alice Mackenzie alone. Cases of women found dead in the streets, courts, and alleys of Whitechapel and the neighbouring districts, in circumstances suggesting violence, without any subsequent arrest, were not without precedent in the police records of the period, though the specific circumstances of any such case beyond those already described in this account are not established in the sources available here, and this account does not draw a connection between Mackenzie's death and any other specific case beyond noting the general pattern of unresolved violence that characterised the district's own history during these years. The physical character of Castle Alley itself continued, in the years following Mackenzie's death, to be described in terms consistent with its condition at the time of the murder. A narrow passage of uneven paving, bounded by the walls of adjoining properties, receiving no direct illumination beyond that cast from the wider street at either end, and subject to the same pattern of nighttime beat patrols that had governed it in July of 1889. Residents of the surrounding streets continued to pass through it in the ordinary course of their daily movements between the lodging houses and the markets and workshops of the wider district, and no record survives of any alteration to the alley's lighting or construction undertaken specifically as a consequence of the events described in this account. The disagreement between Phillips and Bond, recorded at the inquest and preserved in the subsequent literature devoted to the case, continued to be cited in the years following Mackenzie's death as evidence of the genuine difficulty faced by contemporary medical opinion in distinguishing between the work of a single perpetrator and the independent acts of different individuals within a district where violence against women without stable housing or income was, in this period, disturbingly frequent. Later writers examining the case have noted that neither physician's opinion was subjected to further formal testing during the course of the original investigation, and that the question they had disputed was left, at the closing of the file, exactly where it had stood at the inquest. The file generated by the original investigation into the death of Alice Mackenzie, together with the report submitted by Phillips and Bond and the record of the inquest proceedings before Wynne Baxter, was retained within the archives of the Metropolitan Police, alongside the files compiled during the investigation of the murders committed in the district the previous year. These records passed in the course of time into the custody of the National Archives, where they remain available for examination by researchers with an interest in the period, and it is from these retained papers, together with the contemporary newspaper reporting of the case, that later students of the district's history have reconstructed the sequence of events described in this account. The question of how the case ought properly to be classified, whether as a further act by the same individual responsible for the murders of 1888, or as an unconnected killing occurring within the same district, has continued to occupy those who have examined the retained files in the years since. Some among these later researchers have placed particular weight upon the opinion recorded by Baxter Phillips, given his direct familiarity, through his own examinations, with the wounds inflicted in the earlier series, and have concluded on this basis that the death of Alice Mackenzie ought to be treated as a separate matter, arising from different circumstances and, in all likelihood, a different hand. Others have placed comparable weight upon the opinion recorded by Bond, whose own comparative study of the earlier series had been conducted at the request of the police specifically for the purpose of establishing common features among the murders under investigation, and have concluded that his assessment of this case carries corresponding authority. Neither position has displaced the other in the substantial body of writing that has since accumulated around the murders of Whitechapel during this period, and reference works devoted to that subject continue to the present day to record the death of Alice Mackenzie as one of the disputed cases lying at the margin of what is termed within that literature the canonical series, a designation applied to the group of murders considered by the majority of researchers to have been the work of a single individual. Her case is regularly noted as one of several such marginal cases considered for inclusion within or exclusion from that designation, without the question ever having been resolved to the satisfaction of all who have examined it. The absence of resolution in this case did not prevent the Metropolitan Police from continuing, through the remaining months of 1889 and into the following year, to maintain a heightened state of vigilance within the district. Nor did it prevent the continued circulation among the press and the public of theories concerning the identity of the individual or individuals responsible for the violence that had befallen women in Whitechapel across this period. No new evidence bearing directly upon the death of Alice Mackenzie is recorded in the surviving files, as having come to light in the months following the conclusion of the inquest, and the case remained from that point forward in the same position it had occupied at the moment the coroner's jury returned its verdict. A documented death, a disputed medical opinion, and no individual identified as responsible. John McCormack continued, so far as the surviving record indicates, to reside within the lodging houses of the district in the period immediately following the death of the woman with whom he had shared his lodgings. Though no further detail of his circumstances, his subsequent residence, or the remainder of his life, has been preserved in any source available to this account. The lodging house on Gun Street, in which the two had lived, continued its ordinary operation, receiving lodgers at the customary nightly rate, its register maintained as required under the licensing conditions then in force, its population renewed from night to night in the manner characteristic of such establishments throughout the district. The wider population of Whitechapel, in the months following the death of Alice Mackenzie, continued to live under conditions that had shaped her own final months. Dense and shifting residence, casual and uncertain employment, and a persistent awareness that violence against women within the district's streets and courts had, across the preceding year, gone unresolved on more than one occasion. This awareness did not abate with the passage of time in the manner that might ordinarily attend the memory of a single, isolated event. It persisted instead as a settled feature of how the district's residents, and those who wrote about the district from outside it, continued to understand Whitechapel through the final years of the 19th century, a place in which the ordinary protections afforded by the law and its officers had, on more than one occasion, proved unequal to the violence visited upon the women who lived within its bounds. The body remained where it had been found for a period following Constable Andrews' discovery, in keeping with standard practice governing the examination of a scene of violent death, while further officers were summoned and the surgeon attached to the division was sent for. Andrews himself remained at the mouth of the alley to prevent any person from entering before the arrival of his superiors, a precaution intended to preserve the ground surrounding the body against disturbance until such time as it could be properly examined. The alley itself, narrow and unlit as it was, offered little in the way of a surface likely to retain a clear impression, but officers nonetheless examined the paving and the adjoining walls in the hours before dawn for any mark or trace that might bear upon the sequence of events without recording, in the surviving files, any finding of significance beyond the position and condition of the body itself. Word of the discovery spread through the surrounding streets within a short time of the alarm being raised, in the manner characteristic of a district in which news travelled quickly between lodging houses and public houses regardless of the hour. By the time the first light of morning reached Castle Alley, a number of residents had gathered at either end of the passage, held back by the constables posted there, seeking what information could be had of what had occurred. This gathering grew through the early hours of the morning as the news passed further afield, drawing observers from beyond the immediate neighbourhood, and the police were required to maintain a presence at the scene considerably longer than would ordinarily have been necessary in order to manage the numbers who had assembled. The body was removed from the alley once the necessary examination of the scene had been completed, conveyed by police conveyance to the mortuary maintained by the parish for the reception of persons who had died within its bounds by violence or under circumstances requiring further inquiry. It was at this mortuary that the formal identification of the deceased was undertaken, a step required before the inquest could proceed and before the police could direct their inquiries toward those who had known her in life. John McCormack was called upon to perform this identification, confirming to the officers present that the woman who had been found in Castle Alley was indeed Alice Mackenzie, with whom he had shared his lodgings on Gun Street. The formal identification once made allowed the investigation to proceed on a settled basis as to the identity of the victim, a foundation upon which the subsequent inquiries into her movements and circumstances were built. Reporters from the London press had, by this stage, begun to gather in the vicinity of both the mortuary and the alley itself, seeking such information as the police were prepared to release, and such accounts as could be obtained from residents of the district who had witnessed the gathering crowd or who could offer any detail of the deceased woman's life on Gun Street. The accounts that appeared in the following morning's newspapers drew heavily upon these sources, describing the discovery, the location, and such particulars of the victim's identity and circumstances as had been established in the hours immediately following the alarm, while noting, in terms consistent with the district's recent history, the immediate question of whether this death bore any relation to the murders of the preceding autumn. The mortuary itself, a modest structure maintained for the reception of the parish dead under circumstances requiring official examination, had by this date become a familiar destination for the officers and physicians of the division, given the frequency with which sudden and violent deaths within Whitechapel required its use. Its keeper maintained a register of those received into its care in a manner comparable to the registers maintained by the lodging houses of the district, recording the date and circumstance of each admission. And it was against this register that the formal record of Alice Mackenzie's death was first entered prior to the opening of the inquest before Wynne Baxter. The examination of the body conducted at the mortuary, distinct from the preliminary observations made at the scene itself, was carried out with the degree of care that the case's association with the unresolved murders of the previous year demanded, and it was from this examination that the medical opinions subsequently placed before the coroner's jury were derived. The presence of both Baxter Phillips and Thomas Bond at this stage of the proceedings, each conducting his own assessment of the injuries before forming the opinion later presented at the inquest, reflected the seriousness with which the police regarded the need to establish, so far as the evidence permitted, whether this death formed part of the same series that had so gravely troubled the district the year before. The inquest itself was convened in keeping with the ordinary practice governing such proceedings within the coroner's jurisdiction, at a local venue suited to the purpose, the jury drawn from among the ratepayers of the district, as the law then required, men bound by their standing as householders, to serve when called upon in matters of this kind. The swearing in of the jury preceded the taking of evidence, a formality observed at the opening of every session, after which the coroner proceeded to lay before them the circumstances of the case as they had been established to that point, before calling the first of the witnesses to give testimony under oath. The proceedings extended across more than a single sitting, the inquest being adjourned between sessions to allow time for further evidence to be gathered and for the medical examination to be completed in full before the physicians were called to present their findings. This pattern of adjournment was itself a familiar feature of inquests conducted into cases of this nature within the district, the coroner exercising his discretion to allow the necessary time for investigation to proceed alongside the formal hearing of evidence, rather than compressing the whole of the proceedings into a single, uninterrupted session. At each sitting, the jurors were seated to hear the evidence presented in turn, first from Constable Andrews as to the circumstances of the discovery, then from the physicians as to the findings of their examination, and then from such other witnesses as had been gathered by the police in the course of their inquiries among the residents of Gun Street and the surrounding lodging houses. The coroner himself, Wynne Baxter, conducted the questioning of each witness in the manner customary to his office, drawing out the relevant facts before permitting members of the jury to put such further questions as they considered necessary to their own understanding of the case. The evidence of Baxter Phillips and of Thomas Bond, presented as it was in terms that diverged from one another as to the relationship between this death and the murders of the previous year, required the jury to weigh two professional opinions that could not both be reconciled, a circumstance that added to the length and the difficulty of the proceedings beyond what might ordinarily have attended an inquest of this kind. The jurors were instructed, in keeping with standard practice, that their task was to determine the cause of death, and so far as the evidence permitted, the person or persons responsible, and that where no individual could be identified upon the evidence before them, a verdict framed in general terms against a person or persons unknown was the appropriate and lawful conclusion to record. Following the conclusion of the evidence, the jury withdrew to consider its verdict in keeping with the ordinary procedure of a coroner's court, and returned after a period of deliberation to deliver its finding in the presence of the coroner and those officers of the Metropolitan Police who had attended the proceedings on behalf of the investigation. The verdict, recorded as willful murder against some person or persons unknown, closed the formal proceedings of the inquest itself, though it did not close the investigation, which continued under the direction of the police in the weeks that followed, pursuing such further inquiries as the evidence gathered during the inquest process suggested might yet bear fruit. The closing of the inquest was reported in the London press in terms that emphasised the continuing uncertainty surrounding the case, and in particular the disagreement recorded between the two physicians, which was presented to readers as evidence of the genuine difficulty faced by those charged with determining whether Whitechapel remained subject to the depredations of a single individual or had instead become, through the accumulated weight of separate and unconnected violence, a district in which such deaths had come to occur with a frequency that no longer required the presence of one man alone to explain. The newspapers that had covered the district throughout the previous year's murders resumed, in the days following the Mackenzie inquest, their established pattern of close attention to Whitechapel's affairs, publishing accounts that traced the movement of the investigation from the initial discovery through the medical examination and the inquest proceedings, and continuing thereafter to report upon any development, however minor, that touched upon the case. The East London Observer, a paper with long-established coverage of the district's affairs, and the wider London press, including papers of national circulation, gave the case sustained attention through the remainder of July and into August of 1889, a degree of coverage disproportionate in the ordinary course of events to a single, unresolved death, but consistent with the continuing anxiety that Whitechapel's murders of the previous autumn had left unresolved in the public mind. This continued press attention sustained in turn the activity of a body of local residents who had organised themselves, in the aftermath of the murders of 1888, into a voluntary association undertaking to patrol the streets of the district during the hours of darkness, in support of the official efforts of the Metropolitan Police. This association, formed initially among tradesmen and residents of the parish of St Jude in Whitechapel, had continued its patrols intermittently through the months following its establishment, and the death of Alice Mackenzie in July of 1889 renewed for a period the urgency with which its members undertook this voluntary duty, walking sections of the district's streets and courts during the night, in addition to the constables of H Division, already assigned to the same ground. The presence of these volunteer patrols, walking alongside the uniformed constabulary through streets such as those surrounding Castle Alley and Gun Street, reflected the degree to which the district's own residents had come to regard official protection as insufficient to the danger they perceived in their own streets, a perception reinforced rather than dispelled by the outcome of the Mackenzie investigation. Their patrols were conducted without any statutory authority beyond the ordinary rights of any citizen to walk the public streets, and their effect upon the actual prevention or detection of crime within the district is not established in the sources available for this account, though their continued activity through this period is itself a documented feature of the district's response to the events of July 1889. The economic circumstances that had placed Alice Mackenzie within the lodging houses of Gun Street were shared by a great many women resident in Whitechapel during these years, for whom the range of available employment was narrow and precarious. Seasonal work such as hop picking in the counties surrounding London drew a portion of the district's population away from the city during the late summer months, while charring, laundry work, and casual employment in the markets and small workshops of the district provided the more usual means by which women without a settled trade or a stable domestic income supported themselves through the remainder of the year. Alice Mackenzie is recorded in testimony given at her inquest as having worked as a washerwoman and charwoman in the period preceding her death. The file maintained by the Metropolitan Police in connection with the investigation into her death was subject, in the years that followed its initial compilation, to periodic review in keeping with the ordinary administrative practice governing unresolved cases of serious crime, a process by which such files were consulted afresh whenever some new circumstance, however slight, appeared to bear upon their contents. No such circumstance is recorded in the sources available for this account as having arisen in connection with the death of Alice Mackenzie in the years immediately following 1889, and the file remained through this process of periodic review in substantially the same state it had reached at the conclusion of the original investigation, a record of a death by violence, a disputed medical opinion as to its authorship, and no individual identified as responsible. Whitechapel High Street, into which Castle Alley opened at its northern end, formed one of the principal thoroughfares of the district, along which market traffic bound for Spitalfields Market to the north had by tradition begun to move well before the ordinary hours of business, carters and porters passing along the street from the small hours of the morning onward in preparation for the market's opening. The proximity of this early market traffic to the mouth of Castle Alley meant that the alley itself, though narrow and unlit, lay within a stretch of the district that was never entirely without movement, even in the deepest hours of the night, a circumstance that made the absence of any witness to the attack upon Alice Mackenzie the more notable to those who investigated her death, and which was remarked upon at the time as evidence of the speed and the quiet with which the act had been carried out. The wider parish of Whitechapel, of which Castle Alley and Gun Street formed a part, held a population numbering in the tens of thousands within an area of modest extent, packed into streets and courts constructed in an earlier period of the city's growth, and subsequently subdivided and overcrowded far beyond the capacity for which they had originally been built. This density of population, combined with the constant movement of residents between lodging houses of the kind in which Mackenzie and McCormack had made their home, produced a district in which a very great number of persons might, on any given night, have passed within a short distance of Castle Alley without any one of them being in a position to observe what took place within it, a circumstance well understood by the investigating officers and reflected in the caution with which they treated the absence of witnesses as evidence of concealment rather than as evidence of any particular improbability in the crime itself. The retained files of the investigation, together with the newspaper accounts and the record of the inquest proceedings, have in more recent decades become accessible to a wider body of researchers than the police officers and coroner's officials who first compiled them through the digitisation and publication of contemporary records by archives and by specialist organisations devoted to the study of the Whitechapel murders. It is through these channels that the disagreement between Bagster Phillips and Thomas Bond, together with the verdict returned by Wynne Baxter's jury and the testimony of Constable Andrews, has been preserved and made available for continued examination, allowing successive generations of researchers to revisit the same body of evidence without the benefit of any material that was not already available to the original investigators. This continued accessibility has not in the years since produced any resolution to the central question raised at the time of the case, namely whether Alice Mackenzie's death formed part of the series of murders committed in the district during 1888, or whether it represented a separate and unconnected act of violence occurring by unhappy circumstance within the same streets and against a woman of similar circumstances to those who had died the year before. Researchers examining the surviving medical reports have, in some instances, sought to test the opinions of Phillips and Bond against later developments in the understanding of wound patterns and methods of attack, without reaching any conclusion accepted broadly enough to displace the original disagreement recorded at the inquest. The case has, for this reason, retained its position within the specialist literature as one of the unresolved questions attaching to the broader history of violence against women in Whitechapel during these years, a position it has held consistently since the original disagreement between the two physicians was first placed on record, and one that the passage of time and the accumulation of further study has served to preserve rather than to settle. No arrest was ever made. The investigation was formally closed. The case remains open. The record remains incomplete. That is where the record of the second case ends. We turn now to a third and final story, quieter still than the two that came before it. One that unfolded not in a district shadowed by a famous unsolved series, but in an ordinary street of small tradespeople, where the question left behind was not who a victim truly was, but what hour of an otherwise unremarkable day a crime actually occurred. The case of Sarah Squires and her daughter Christiana Squires begins in Hoxton, in the northeastern quarter of London, in the summer of 1872. Hoxton in this period formed part of the parish of Shoreditch, a densely built district of small streets, workshops and shop fronts that had grown rapidly over the preceding decades to accommodate the expansion of London's working and lower middle classes. The district was known for furniture making, small manufacturing trades and retail premises of modest scale, many of them run by families who lived above or behind the shops they kept. Hyde Road, where the Squires family conducted business, was a street of this ordinary commercial character, lined with terraced buildings that combined a ground-floor shop with living quarters to the rear and above. The population of Shoreditch at this time numbered in the tens of thousands, and Hoxton itself was considered a respectable, if unremarkable, working commercial neighbourhood, distinct from the more notorious districts further east. The summer of 1872 in London was a period of ordinary civic life. The city's population continued to expand, its streets crowded with horse-drawn traffic, and its shops open through long daylight hours to serve a clientele of local residents and passing trade. Number 46 Hyde Road was among these shops, a wholesale picture and print business that supplied prints, engravings, and framed images to smaller retailers and to members of the public. The trade in prints and pictures was a recognised commercial line in Victorian London, serving a public appetite for decorative images, portraits, and reproductions that could be purchased inexpensively and displayed in the homes of those without means to commission original artwork. A business of this kind required the regular handling of stock and of cash taken in from customers and other tradespeople, and it operated during standard daylight hours, consistent with other small commercial premises on the street. Sarah Squires was a widow who'd continued the business established by her late husband. Documentary sources do not establish the date of her husband's death or the precise circumstances under which she assumed control of the enterprise, but her position as proprietor of a wholesale picture and print business in her own name was, for a woman of her generation, a notable undertaking. Widows who continued a deceased husband's trade were not uncommon in Victorian commercial life, particularly in trades that did not require specialised licensing, and Sarah Squires appears to have managed the Hyde Road premises with the direct assistance of her daughter. The available record does not establish details of Sarah Squires' own parentage, her place of birth, or the composition of her household beyond her daughter and, separately, a son who does not appear to have resided with her at the time of the events described here. The record available for this account does not establish further particulars of her early life with certainty. Christiana Squires was Sarah Squires' unmarried daughter, and she lived and worked alongside her mother at the Hyde Road premises. The nature of an unmarried daughter's continued residence with a widowed mother and her participation in the family trade was a common arrangement in households of this kind, particularly where a business required more than one pair of hands to manage stock, serve customers, and maintain the premises. The record does not establish further biographical detail regarding Christiana Squires' earlier life, her education, or her activities outside the family business. What is established is that she was present at the shop in the ordinary course of its operation, and that her daily routine was bound closely to her mother's through their shared occupation. One further figure connected to the Squires household requires mention at this stage of the record. Not as a participant in the events of July 1872, but as a lead that investigators later pursued and eliminated. Sarah Squires had a son who, at the time of the murders, was confined in the lunatic ward of the Shoreditch workhouse. Because he was a male relative with some connection to the household and its affairs, police investigators considered him in the course of their inquiries. He was subsequently ruled out as a suspect on the straightforward basis that his confinement placed him elsewhere at the time the crimes were committed. The record does not provide his given name, and it establishes nothing beyond his institutional confinement and his elimination from suspicion. He is noted here only because the investigation itself noted him, and because the historical record requires that this line of inquiry, however briefly pursued, be acknowledged as closed without further implication. If you find value in histories preserved this way, consider liking the video and subscribing to the channel. What follows begins in Hoxton in 1872. The circumstances preceding the events of the 10th of July 1872 were, so far as the record establishes, entirely ordinary. The Squires family shop at 46 Hyde Road operated as it did on any other trading day, with stock arranged for sale and the premises open to receive customers and passing tradesmen. The available sources do not document any particular dispute, threat, or unusual occurrence in the days or weeks preceding the crime that might have signalled danger to either woman. No record survives of a disagreement with a creditor, a dismissed employee, or an aggrieved customer that investigators were able to connect to what followed. The absence of any such warning is itself part of the historical record, and it is consistent with the nature of the crime, as it was later understood, a crime that appeared to investigators to bear the marks of an opportunistic robbery, rather than the culmination of a personal grievance. On the morning of the 10th of July, both Sarah Squires and Christiana Squires were seen alive and about their ordinary business. Multiple witnesses in the vicinity of Hyde Road later gave accounts placing one or both women in or near the shop between approximately 9 and 11 o'clock. These sightings were consistent with the routine operation of a shop of this kind, opening for the day's trade and receiving whatever customers or deliveries the morning brought. The presence of both women at the premises during these hours was not disputed by any witness whose account survives in the record. What became disputed, and what remained disputed for the whole of the subsequent investigation, was what happened afterward, and at what hour the ordinary business of the morning gave way to the crime that ended both of their lives. The shop at 46 Hyde Road, in the ordinary course of business, would have presented an unremarkable scene to any passer-by on the morning of the 10th of July. Prints and pictures would have been displayed for sale within, the counter set for the receipt of payment, and the daily transactions of a small wholesale trade proceeding, as they had on countless other mornings. It is worth setting down, for the purposes of this record, the plain and undramatic character of the setting in which the crime occurred, precisely because that ordinariness stands in such stark contrast to what was discovered later in the day. There was, so far as any surviving account establishes, nothing in the appearance of the shop or the conduct of its proprietors that morning to suggest that anything was amiss. At some point during the late morning or early afternoon of the 10th of July, 1872, Sarah Squires and Christiana Squires were killed inside the shop at Hyde Road. Both women were struck with a heavy implement, consistent with a hammer or an iron bar, and both died of the injuries inflicted upon them. The injuries were severe and rapidly fatal, and the shop itself was left in a state of disarray, its contents disturbed in a manner consistent with a search of the premises. The available sources do not establish precisely what, if anything, was taken from the shop, and the record does not confirm with certainty whether robbery was the actual motive for the crime, or whether the disturbance of the premises was arranged to suggest a motive that did not, in fact, drive the killings. What is established is that 2 women were dead, that the means of death was blunt force injury from a heavy object, and that the shop bore the marks of having been searched or ransacked in the course of, or following, the attack. The bodies of Sarah Squires and Christiana Squires were discovered in the early afternoon of the 10th of July. A boy named William Eyre had been sent to the shop on an ordinary errand, the nature of which the surviving record does not specify, beyond its being routine business of the kind that would bring a messenger or delivery boy to premises of this sort. Arriving at the shop at approximately 1:30 in the afternoon, William Eyre knocked at the premises and received no answer, an occurrence unusual enough given the hour and the shop's ordinary hours of business to prompt him to look further rather than simply depart. It was in the course of this closer inspection that he observed marks of blood upon the counter within the shop. Recognising the significance of what he'd seen, William Eyre raised the alarm, and it was through his actions that the deaths of Sarah Squires and Christiana Squires came to be discovered and reported to the authorities. The discovery of the bodies set in motion the investigation that would occupy the police in the weeks that followed, an investigation that would ultimately fail to identify any person responsible for the deaths of the 2 women. The circumstances of the discovery, an ordinary errand interrupted by an unanswered door and the sight of blood upon a shop counter, established the timeline from which all subsequent inquiry proceeded, even as that same timeline would prove impossible to reconcile with the accounts of witnesses who believed they had seen the shop open, and one or both women alive, considerably later in the morning than the hour investigators would eventually come to regard as the probable time of the attack. That contradiction between what witnesses believed they had seen and what the discovery of the bodies at 1:30 seemed to require became the central and enduring difficulty of the case, a difficulty that was never resolved to the satisfaction of the investigators who pursued it. The investigation into the deaths of Sarah Squires and Christiana Squires was formally opened in the hours following the discovery of the bodies on the 10th of July 1872. Officers of the local constabulary were dispatched to the scene at Hyde Road, where they undertook an examination of the premises, noting the disturbed state of the shop's contents and the position and condition of the 2 bodies as they had been found. The disarray of the stock and fittings within the shop was recorded as consistent with a search of the premises, whether by the perpetrator seeking cash or portable goods, or by some other agency, and this observation shaped the investigators' initial understanding of the crime as one committed in the course of, or for the purpose of, robbery. No determination survives in the record as to precisely what items, if any, had been removed from the shop, a gap that limited the usefulness of the ransacked premises as evidence of the perpetrator's specific intentions. Officers proceeded to take statements from residents and tradespeople in the immediate vicinity of Hyde Road, in the standard practice of establishing a timeline of movements and sightings around the premises on the morning and early afternoon in question. It was through this process of gathering statements that the central evidentiary difficulty of the case first became apparent. Several witnesses gave accounts consistent with the 2 women being seen in or about the shop between approximately 9 and 11 o'clock in the morning, a time frame that investigators could readily reconcile with the ordinary business hours of the premises. One witness, however, was firm in an account that placed Sarah Squires standing in the doorway of the shop as late as 12:30, a time considerably closer to the hour of the discovery than the other sightings allowed. Investigators were unable to reconcile this account with the other evidence gathered, and the contradiction between the two sets of witness statements was never resolved in the course of the inquiry. The disputed timeline bore directly upon the investigators' ability to narrow the window during which the murders might have occurred, and by extension, their ability to identify who might have had opportunity to commit them. If the earlier sightings were correct and the women had not been seen alive after approximately 11 o'clock, the crime might have occurred at any point across a span of more than 2 hours before the shop was found silent. If the later sighting was correct and Sarah Squires had indeed been seen alive at 12:30, the window during which the murders could have taken place was compressed to little more than an hour, a compression that ought, in principle, to have narrowed the field of possible witnesses or passers-by who might have observed a perpetrator entering or leaving the premises. Investigators were unable to determine which account or accounts to credit, and the contradiction persisted through the whole of the inquiry without resolution. Beyond the question of the timeline, the investigating officers pursued the ordinary lines of inquiry appropriate to a case of this kind. Statements were taken from tradesmen who supplied the Squire's shop, and from customers known to have dealt with the business in the days before the crime, in an effort to establish whether any recent transaction or visit to the premises might account for the presence of a stranger with knowledge of the shop's routine. No such connection is recorded as having been established with any confidence. Inquiries were also made among the immediate neighbours on Hyde Road, tradespeople and residents whose own premises stood in close proximity to number 46, in the hope that someone might have observed an unfamiliar figure entering or leaving the shop, or heard some disturbance from within. The record does not indicate that any witness came forward with an account of this kind sufficient to advance the inquiry. The one substantive lead that investigators did pursue with particular care concerned Sarah Squires' son, a relative whose connection to the household made him, in the ordinary logic of such an investigation, a figure meriting attention. Officers established in the course of their inquiries that he was at the time of the murders confined in the lunatic ward of the Shoreditch workhouse, a fact that was verified to the satisfaction of the investigation and that removed him from consideration as a suspect. This elimination was recorded as definite, resting as it did on his institutional confinement rather than on any weighing of character or opportunity, and the investigation did not return to him at any later stage. With this lead closed, and with no other named individual emerging from the statements gathered in the vicinity of Hyde Road, the investigation was left without a suspect whose movements could be tested against the disputed timeline of the morning and early afternoon. A post-mortem examination was conducted upon the bodies of both Sarah Squires and Christiana Squires in the days following their discovery. The examination established that both women had died as a result of blunt force injuries, consistent with blows from a heavy implement of the kind that might be represented by a hammer or a length of iron bar, and that the injuries sustained by each woman were sufficient to have caused death without prolonged survival. The examining physician's findings were consistent between the two victims, indicating that both had been subjected to a similar manner of attack rather than to distinct or dissimilar assaults. Though the sources reviewed for this account do not preserve the name of the physician who conducted the examination, nor do they record further particulars of the findings beyond the established cause of death. No inconsistency in the medical evidence is recorded as having troubled the investigation. The difficulty in this case lay not in establishing how the two women had died, but in establishing when. The findings of the medical examination were considered in due course before a coroner's inquest convened to inquire into the deaths of Sarah Squires and Christiana Squires. An inquest of this kind was the standard legal procedure required following any sudden or violent death within the jurisdiction, and it would have involved the coroner hearing evidence from those who discovered the bodies, from the officers who investigated the scene, and from the physician who had examined the remains, together with such witness testimony as bore upon the circumstances of the deaths. The surviving record does not preserve the name of the coroner who presided, nor the precise wording of the verdict returned, though a verdict of willful murder against some person or persons unknown would have been the customary finding in a case of this character, where the fact of murder was not in doubt but the identity of the perpetrator could not be established. It is at the inquest, more than at any other stage of the proceedings, that the disputed testimony regarding the time of the women's deaths would have been aired most fully, with witnesses called to give their accounts of the morning's sightings under the coroner's direct questioning, and with the contradiction between the earlier and later accounts left, so far as the record establishes, unresolved even under that scrutiny. No suspect was ever brought before a magistrate in connection with the deaths of Sarah Squires and Christiana Squires, and consequently no trial took place. The investigation, having exhausted the leads available to it, among them the elimination of Sarah Squires' son and the fruitless canvass of neighbours and tradespeople along Hyde Road, was unable to identify any individual against whom sufficient evidence could be brought. The case remained, in the language of the period, one in which the perpetrator or perpetrators were unknown, a classification that carried with it no expectation of future resolution beyond whatever new information might, in principle, come to light. The disturbed state of the shop, taken together with the absence of any personal motive established against either woman, continued to point investigators toward robbery as the probable object of the crime, though the record does not permit certainty even on this point, and it remains possible on the evidence available that the appearance of a robbery was other than what it seemed. The shop at 46 Hyde Road did not resume its former character as an ordinary commercial premises in the immediate aftermath of the crime, its front closed to the trade that had passed through its door on countless prior mornings. The available sources do not establish what became of the business itself, whether it was sold, closed outright, or continued for a time under different management, nor do they record the subsequent history of any surviving relatives of Sarah and Christiana Squires beyond the son, whose confinement had placed him outside the events of that July day. The record, in this respect, falls silent, and no account of the family's later circumstances survives in the sources reviewed for this history. The case of Sarah Squires and Christiana Squires persisted in a modest and specialised way within the wider record of Victorian London's unsolved crimes, appearing in later compilations devoted to lesser-known murders of the period, among them a scholarly survey of overlooked Victorian cases that placed the Hoxton killings alongside other crimes that never achieved the notoriety of their more famous contemporaries. Digital archives devoted to the reproduction and summary of contemporary press accounts of Victorian London crime have likewise preserved the essential facts of the case, ensuring that the deaths of the two women were not lost entirely to record, even as they faded from public memory. Occasional modern journalism concerned with unsolved historical mysteries has included the case among catalogues of unresolved British crimes, generally repeating the same essential facts: the double killing, the ransacked shop, the boy who discovered the blood upon the counter, and the disputed hour of the women's deaths. No play, ballad, or dramatic adaptation of the case is recorded as having been produced, and it has exercised no discernible influence upon subsequent law or police practice, remaining instead a case known chiefly to those with a particular interest in the less prominent corners of Victorian criminal history. The commercial life of Hoxton in the early 1870s provides the proper context in which to understand both the ordinariness of the Squires family circumstances and the vulnerability inherent in a small shop of this kind. Premises such as 46 Hyde Road, combining retail trade with domestic residence, were common throughout the district, and they shared certain practical characteristics that bore directly upon the crime committed there. Such shops customarily kept the day's takings on the premises rather than transferring them elsewhere until the close of business, and their proprietors, particularly where the household consisted only of a widow and her unmarried daughter, had limited means of defending the premises against an intruder determined upon robbery. The daytime hours during which such a shop stood open to any member of the public who cared to enter created an opportunity that a determined individual might exploit with comparatively little risk of immediate detection, particularly if the crime were committed swiftly and the premises searched before any alarm could be raised. The Squire's case, considered in this light, reflects a recognised pattern of urban crime in the period: the daytime robbery murder of shopkeepers whose premises offered both cash and privacy to anyone willing to commit violence to obtain them. Sarah Squire's position as a widow, continuing her late husband's trade in her own right, situates her, and by extension her daughter, within a broader pattern of limited but genuine commercial independence available to certain women in mid-Victorian London. Widows who carried forward an established business rather than disposing of it or allowing it to pass to a male relative were not unusual in trades that did not require formal licensing or specialised technical qualification, and the wholesale picture and print trade fell readily within this category. Such continuation allowed a woman in Sarah Squire's position to maintain her household's income and social standing without dependence upon remarriage or the charity of relatives, though it also placed her, in a case such as this one, in a position of exposure that a business run by two women alone could not easily guard against. Christiana Squire's role within this arrangement as her mother's daily assistant in the shop reflects the ordinary participation of unmarried daughters in family trades throughout this social stratum, an arrangement of mutual dependence that ended, in this instance, with both women dead upon the same afternoon and within the same small commercial space they had shared in life. The shop itself, in its physical arrangement, followed the customary pattern of a Hoxton trade premises of this character. A single frontage opened directly onto Hyde Road, its window given over to the display of prints and engravings arranged to draw the eye of passers-by, while behind the counter ran shelving and storage for the wholesale stock that formed the greater part of the Squire's trade, bundles of prints intended for resale to smaller shopkeepers rather than for retail purchase by the individual customer. Beyond this front room lay the more private portion of the premises, rooms given over to the storage of additional stock, to the keeping of account books and correspondence with suppliers and customers, and, toward the rear, to whatever domestic quarters the two women maintained above or behind the trading floor. A business of this kind required constant attention to inventory, the unpacking and cataloguing of new stock as it arrived from printers and wholesalers, the wrapping and dispatch of orders to customers in other parts of London, and the daily reckoning of accounts, a set of tasks that would have occupied both Sarah Squires and her daughter through the greater part of any ordinary working day. The wholesale picture and print trade itself depended upon a broader London industry of engravers, lithographers, and publishers who produced the images that shops such as the one on Hyde Road purchased in bulk and resold to a network of smaller retailers, framers, and stationers throughout the city and beyond. A proprietor in Sarah Squire's position would have maintained regular dealings with several such suppliers, receiving deliveries of new prints at intervals and extending credit in the ordinary course of trade to the smaller shopkeepers who purchased from her in turn. This pattern of credit and delivery meant that a certain quantity of cash, representing payments received and payments yet to be made, would ordinarily have been kept upon the premises rather than banked at the close of each day, a practical necessity of the trade that also constituted, as investigators would later have cause to consider, a standing vulnerability for any shop of this kind, particularly one operated without the presence of a man upon the premises during business hours. The morning of the 10th of July would, in the ordinary course of things, have begun for Sarah Squires and her daughter, much as countless other mornings had begun before it, with the unlocking of the shop's front door, the arrangement of the window display to catch the eye of the day's first passers-by, and the setting out of the counter for the reception of custom. Such mornings would have brought a succession of small transactions and minor errands, deliveries received, orders wrapped for collection, brief exchanges with regular customers and with the tradespeople whose own premises lined Hyde Road and the surrounding streets. It was a routine sufficiently established and sufficiently unremarkable that no witness who later gave an account of that morning described anything in the two women's conduct or bearing to suggest apprehension or unusual circumstance. The ordinariness of the morning, as it was later reconstructed from witness testimony, stands as one of the case's most persistent and troubling features, for it offered investigators no point of departure from the routine at which to locate the moment when the day turned from the customary to the fatal. When William Eyre arrived at the shop shortly after 1 o'clock in the afternoon, he did so as any messenger boy might, expecting to complete an errand of the kind he had likely performed at that address before, and to be admitted or attended to in the ordinary way. The silence that met his knock was, in itself, not immediately alarming, for a shop's proprietor might be occupied at the rear of the premises, attending to some task that delayed her answer to the door. It was only as the silence persisted, and as he looked more closely through the window or the gap of the doorway, that William Eyre's attention was drawn to the marks upon the counter within, a sight sufficiently out of keeping with the ordinary appearance of a trading shop that it prompted him to abandon the errand that had brought him there, and to seek help rather than continue waiting for an answer that did not come. The particular chain of observation that led from an unanswered knock to the raising of an alarm, an errand boy's growing unease resolving into the recognition of blood upon a shopkeeper's counter, is preserved in the record as the mechanism by which two deaths that might otherwise have gone undiscovered for hours longer were instead brought to the attention of the authorities within a comparatively short span of the crime itself. The officers who attended the scene at Hyde Road in the aftermath of William Eyre's alarm worked within the investigative limitations characteristic of metropolitan policing in the early 1870s, a period in which the detection of crime depended overwhelmingly upon witness testimony, the physical examination of a scene by trained eyes, and the patient correlation of statements gathered from those in the vicinity, rather than upon any of the forensic techniques that would become available to investigators in later decades. There existed at this date no means of identifying an individual perpetrator through fingerprint evidence, no established system of matching physical trace evidence to a particular suspect, and no photographic or documentary registry of criminal offenders comparable to those that would later assist detectives in narrowing a field of suspects. An investigation of this kind rested, therefore, almost entirely upon the willingness and the reliability of those who'd been in the vicinity of the crime to come forward and to give a truthful and accurate account of what they had seen. A reliance that made the contradiction between the earlier and later sightings of Sarah Squires all the more damaging to the prospects of the inquiry, since no independent means existed by which investigators might test one account against the physical evidence and determine which, if either, was mistaken. The house-to-house canvass conducted by officers in the streets surrounding Hyde Road would have proceeded in a systematic fashion characteristic of the period's policing practice, with constables calling at each neighbouring premises in turn to ask whether the occupants had observed anything unusual in the vicinity of the Squire's shop on the morning or early afternoon of the 10th of July. Such an inquiry would have taken in not only the immediate neighbours of number 46, but tradespeople and residents somewhat further along the street, together with anyone whose ordinary business might have brought them past the shop at a relevant hour, delivery carters, other errand boys, and customers of neighbouring establishments. The absence in the surviving record of any account beyond the disputed sightings already noted suggests that this canvass, thorough as it evidently was, failed to produce a witness who could describe a stranger entering or leaving the premises, a gap in the evidence that left investigators without the single piece of testimony that might have resolved the case. Cases of this general character, the daytime murder of a shopkeeper in the course of an apparent robbery, were not unknown to the police of London in this period, and the investigation into the deaths of Sarah Squires and Christiana Squires would have proceeded with an awareness, on the part of experienced officers, of the general pattern such crimes tended to follow. A perpetrator, acting alone, entering a shop during business hours under the pretext of custom, might overpower a proprietor with a single, sudden blow before searching the premises for cash or portable goods, relying upon the ordinary traffic of customers in and out of a trading shop to avoid particular notice at the moment of entry. The presence of two women rather than one within the Hyde Road shop, however, distinguished this case from the more common single victim pattern, requiring that a perpetrator either overcome both women in turn or take each of them sufficiently by surprise that neither could raise an alarm before the other was also attacked. This circumstance, that two women rather than one were killed within what the record indicates was a comparatively brief span of time, was itself among the details that investigators would have weighed in attempting to reconstruct the likely sequence of the crime. Though the surviving sources do not preserve any specific conclusion the investigation reached on this point, the coroner's inquest into the deaths of Sarah Squires and Christiana Squires would have been convened, in keeping with the standard procedure of the period, at a public house or other suitable local building pressed into service for the purpose, coroners' courts of this era rarely possessing dedicated premises of their own in a district such as Hoxton. A jury of local men would have been empanelled, as the law required, to hear the evidence laid before the coroner and to return a verdict upon the facts presented to them, a duty that, in a case of unresolved murder, typically culminated in a finding of wilful murder against some person or persons unknown, a verdict that closed the formal inquest proceeding while leaving the criminal investigation itself open and unresolved. The jury in this instance would have heard, in addition to the medical evidence establishing the cause of death and the testimony of William Eyre regarding the discovery of the bodies, the same contradictory witness accounts of the morning's sightings that had already troubled the police investigation, without any additional evidence available to the coroner that might have resolved the contradiction beyond what the officers themselves had already gathered. The crime attracted the attention of the London press in the days immediately following its discovery. Newspapers of the period customarily reporting cases of violent death within the metropolis in some detail, particularly where the victims were two women killed together, and the circumstances suggested robbery as a likely motive. Reports of this kind would have carried an account of the discovery of the bodies, a description of the disordered state of the shop, and such particulars of the ongoing police investigation as the authorities were willing to make public, together with an appeal to any person possessing relevant information to communicate it to the police at the earliest opportunity. It was customary, in cases of this severity where no suspect had been apprehended, for a reward to be offered for information leading to the identification and conviction of the person or persons responsible. The funds for such a reward, drawn variously from public subscription, from the authorities themselves, or from interested private parties connected to the victims or to the trade in which they had been engaged. Whether a reward was in fact offered in connection with the deaths of Sarah Squires and Christiana Squires, and if so, in what amount, is not established with certainty in the sources reviewed for this account, though the practice was sufficiently common in cases of this kind that its absence, where it can be confirmed, would itself be a notable feature of an investigation, and its presence where it produced no result would stand as a further indication of how thoroughly the case resisted resolution. The verification of Sarah Squires' son's confinement in the lunatic ward of the Shoreditch workhouse, the one substantive line of inquiry that the police were able to close with confidence, would have proceeded through the ordinary channels available to investigators seeking to confirm the whereabouts of a person under institutional care. Asylums of this period maintained registers recording the admission, certification, and continued detention of each patient. Records that a police inquiry could examine, or concerning which asylum staff and medical officers could be questioned directly in order to establish with confidence whether a named individual had in fact been under continuous confinement at the relevant date. The certification of a person as insane and their subsequent admission to an asylum was itself a formal process in this period, requiring the signed certificates of qualified medical practitioners and, in many cases, the involvement of a magistrate, procedures whose documentary trail would have made it a comparatively straightforward matter for investigators to confirm that Sarah Squire's son had indeed been confined at the time of his mother's and sister's deaths, and could not therefore have been present at Hyde Road on the 10th of July. This confirmation, arrived at through documentary and institutional verification, rather than through any process of personal vouching or character assessment, is recorded as having satisfied the investigation, and the inquiry did not revisit the question of his whereabouts at any later stage. Among the tradespeople of Hoxton, the deaths of Sarah Squires and Christiana Squires appear, so far as the record permits any inference on this point, to have occasioned a measure of unease extending well beyond the immediate circle of the two women's acquaintances. A double murder committed in broad daylight within an occupied shop, upon a street lined with premises of a similar character, carried an implication that troubled other small proprietors in the district, many of whom conducted their own trade under circumstances not unlike those at Hyde Road, with cash kept upon the premises and the shop left open to any member of the public who cared to enter during the ordinary hours of business. Shopkeepers of this kind, particularly women operating a business alone or with only a single female relative for assistance, would have had cause to reflect upon their own vulnerability to a crime of the sort that had claimed the lives of Sarah Squires and her daughter, and it is consistent with the general pattern of such crimes in this period that a case of this severity occurring within a settled commercial street, rather than in one of the districts more commonly associated with violent crime, would have prompted at least a temporary heightening of caution among those who kept shops of a similar description in the surrounding streets. The disordered state in which the shop at Hyde Road was found, its stock disturbed and its ordinary arrangement disrupted, would have presented investigators with a scene that required careful and deliberate examination before any conclusion could be drawn as to what, if anything, had actually been taken. A wholesale premises of this kind held stock in considerable quantity, bundles of prints and engravings that might themselves have been disturbed or scattered in the course of a violent struggle without any of them having been removed from the premises at all, a circumstance that would have made it genuinely difficult for investigators, or indeed for anyone familiar with the ordinary stock of the shop, to state with confidence whether the disorder reflected a deliberate search for cash and goods, or merely the physical consequence of the attack itself. This difficulty, in a case where no inventory or accounting record survives to establish precisely what stock or cash the shop held prior to the 10th of July, left open the possibility, never resolved in the surviving record, that the appearance of robbery was exactly what it seemed, a search conducted by a perpetrator seeking specifically to profit from the crime, or alternatively, that the disorder was incidental to some other and undetermined motive, arranged or exaggerated by circumstance, rather than by deliberate design. The case of Sarah Squires and Christiana Squires was not the only instance, in the London of the early 1870s, of a shopkeeper or small tradesperson murdered in the course of an apparent robbery upon their own premises, though the particulars of other such cases from this period lie beyond the scope of this account, and are noted here only to place the Hoxton killings within a recognised, if infrequent, category of urban crime, rather than to suggest any connection between them. Investigators of the period would have approached a case of this kind with an awareness of the general contours such crimes tended to follow, awareness that nonetheless proved insufficient in this instance to produce a suspect against whom the available evidence could be brought to bear. The absence of any comparable case whose resolution might have offered a model for how the Hyde Road murders could be solved left the investigation to proceed upon its own evidence alone, evidence that consisted, in the end, of a disputed timeline, an unresolved question of motive, and no identified individual whose presence at the shop on the morning of the 10th of July could be established or disproved. The formal investigation into the deaths of Sarah Squires and Christiana Squires does not appear, from the sources reviewed for this account, to have been dramatically or publicly concluded at any single identifiable date, but rather to have subsided gradually in the manner characteristic of unsolved cases of this period, as the leads available to investigating officers were exhausted and no new information came forward to sustain active inquiry. Cases of this kind were customarily kept formally open within the records of the police, in the sense that no formal closure was entered so long as the possibility remained, however remote, that some future circumstance might bring forward a witness or a piece of evidence capable of identifying the person responsible. In practice, however, the active pursuit of new lines of inquiry would have ceased once the canvass of the neighbourhood, the examination of the one substantive suspect and the correlation of witness statements had all been carried through without producing a viable suspect, leaving the case to stand thereafter as a matter of record rather than of ongoing investigation. The particular difficulty presented by the disputed hour of the murders, an evidentiary gap that no amount of careful police work was able to close, illustrates a limitation inherent in an investigative system that depended so heavily upon the accuracy of individual human recollection. A witness who believed with sincerity that she had seen Sarah Squires standing in the doorway of the shop at 12:30 was not necessarily mistaken through any fault of observation or honesty, and the investigators of 1872 possessed no means, beyond the weighing of one account against another, by which to test the reliability of competing recollections offered in good faith. The case of Sarah Squires and Christiana Squires stands in this respect as an illustration of how a crime might be discovered promptly, its physical facts established without great difficulty, and its investigation pursued with diligence, and yet remain permanently unresolved for want of the one piece of evidence, whether a reliable timeline or an identified witness to the perpetrator's presence, that no diligence could supply where the underlying facts themselves could not be recovered. Sarah Squires, at the time of her death, was a woman in her 70s, having carried on the family trade for a considerable span of years as a widow before the events of the 10th of July brought that trade to an abrupt and permanent end. Christiana Squires, her daughter, was a woman in her 30s, her adult life spent almost entirely in the service of the shop she and her mother maintained together. The precise ages of both women are not established with certainty in the sources consulted for this account, contemporary reports differing slightly on the point, and the record available does not permit a more exact reckoning than this. What is established beyond dispute is that both were adult women, one considerably advanced in years, the other in the settled middle of her working life, and that both met their deaths within the same brief span of time, and within the same small commercial room in which they had spent so great a part of their days. No record survives, among the sources reviewed for this account, of the funeral arrangements made for Sarah Squires and Christiana Squires, nor of the manner in which the wider Hoxton community marked the deaths of two women so well known along Hyde Road through years of ordinary daily trade. Funerals of this period, for tradespeople of the Squires family standing, would customarily have drawn neighbours and fellow shopkeepers to observe the passage of the two coffins. Through streets the women had walked every working day of their adult lives. Though no specific account of such a gathering, its scale or its character has been preserved in the sources available for this history. The record, in this respect, as in several others touching upon the personal and family aftermath of the crime, falls silent, leaving only the bare fact of the deaths and the investigation that followed them as the substance of what can be known with confidence. The case would, in the ordinary course of the Metropolitan Police's administration, have been entered among the year's tally of crimes committed within the district, a tally that distinguished, as a matter of routine record-keeping, between offences that had resulted in an arrest and conviction and those that remained at the close of the year without any person brought to justice. The deaths of Sarah Squires and Christiana Squires would have been counted among the latter category, a double murder entered into the annual record of undetected crime for the district of Shoreditch, one figure among the wider statistics of violent offences that the Police of London compiled and reported as a matter of administrative routine, without any suggestion in such a tally of the particular human circumstances. The ransacked shop, the disputed hour, the boy who found the blood upon the counter, that lay behind the bare classification of the case as murder, undetected. The case of Sarah Squires and Christiana Squires was the last of these three cases to enter the historical record. No arrest was ever made. The investigation was formally closed. The case remains open. The record remains incomplete.